Hey everybody, this is Chuck Marone with Strong Towns. It is spring in Minnesota and everybody's out mowing today. Got a little bit of rain, so the grass grew and everybody's going crazy getting out mowing. It's pretty cool, but I will try to do this unmolested by lawn mowers. We'll see. I want to talk about a recent Supreme Court case. The case was actually called Sheets versus the County of El Dorado out of California. It was a unanimous decision and it overturned lower court decisions and a city ruling on land use. So it's pretty important. I want to set the stage by talking about two rather famous, rather influential land use decisions from the 1980s. The first one being Nolan versus the California Coastal Commission, and the second one being Dolan versus the city of Tigard. These two cases established the principles of nexus and proportionality when you're reviewing local land use permits. It's why the city is limited in what they can do. In Nolan versus the California Coastal Commission, what you had was someone who had come in for a permit. I can't remember what the permit was. It was like a house addition or something like that. And the Coastal Commission said, hey, we'll approve your permit, no problem, we can do that. But in order for us to approve it, you have to give us an easement across your shoreline. We're trying to create a public corridor along the shoreline. We think that's in the public's interest, the public good. We're trying to create this corridor. And so we're asking you to give us this land in order to get your permit. That was appealed, went all the way to the Supreme Court. Supreme Court, in opinion written by Justice Scalia at the time, said, hey, you can't do that. That's extortion. You actually can't say, we'll give you the permit in exchange for you giving us something. That is a takings by the US Constitution. Can't do it. And he established this principle called a nexus, saying there's got to be a nexus, there's got to be a connection between the impact that the development is going to have and the thing that you're asking for, the thing that you're asking them to do. If you are putting an addition on the side of your house, there's no connection between that and the state's desire for a trail along the beach. Trail along the beach might be a great desire, but you've got to acquire it in a different way. You've got to use eminent domain or what have you. You're going to have to compensate for them for it. That's a takings. In Dolan versus the city of Tigard, then, you had the city actually following the nexus, but they lacked proportionality. In this case, there's someone looking to do a commercial development. That commercial development was going to have runoff impacts. There's going to be more stormwater runoff. And what the permitting agency said is, hey, we'll give you a permit to do that. We'll let you do that. But you need to cede to the city, to the community, a whole bunch of your land for stormwater management. More land than what your actually stormwater would create. Again, went all the way to Supreme Court. Scalia wrote the opinion again, said, hey, no, again, takings, you got the nexus right, stormwater runoff, stormwater area, but this is not proportionate. There's no proportion between, we're out of proportion between the impact that this property will cause and what you're asking them to do. You're asking them to shoulder a larger burden than the impact that they will have. And so these two ideas, nexus and proportionality, have kind of become the basis for how we write permits. For when you go through a public hearing process, you go through any type of permitting process, the local government is limited by, in theory, right, is limited by this idea of you can only ask for or condition things that are directly created or direct impact of the development, and it's got to be proportionate to the impact that you have. All right, now enter this new case, Sheets versus the County of El Dorado. And this one's interesting because it's about traffic impacts. The state of California has adopted essentially a traffic impact fee. And they assess this essentially over the entire county. They've said, you're allowed to do this county. County went out and assessed it over the entire county. And they basically came up with this notion that if you add a new house, it has X amount of impact. And I want to say it was like $22,000 per new house, some like insane amount. They just leveled that over the entire county. And you can see how they're trying to do both things, right? They're trying to create a nexus. You're building a new house, it's going to create traffic impacts. And they're trying to do proportionality by saying, here's the overall impact of new homes across the county. Amount of impact divided by number of new homes equals your proportion of that, right? The state courts approved that. Federal courts approved that. Appeals courts approved that. Got to the Supreme Court, 9-0. They said, nope, not going to go. The core thing that was being argued here, there were a bunch of things. The nexus was not being argued. Proportionality was being argued. Supreme Court did not rule on that. Supreme Court sent that back to be reconsidered. But the core argument that the Supreme Court debated was whether this can be done legislatively. In other words, it wasn't a planning commission, it wasn't a city, it wasn't a permitting agency that put this fee into effect. It was a statewide legislation. And so because it's statewide legislation, because it's legislated, not done administratively, would that be looked at differently? And the answer the Supreme Court said was no, it's going to be the same. It's a takings either way. And so now this is going to go back to the state, back to lower courts, and they're going to determine whether the guy building like a modular home out in the middle of nowhere, really is what it sounded like, is going to have to pay a $22,000 fee to the county for traffic impacts.